Good morning, everyone.
Good morning, teacher.
Welcome to the course of the WTO law. As usual, let's review what we've learned last week by only two basic questions. Okay, two basic questions. Question number one. About the methods of AB treating panel reports after the appellate review. How many methods are there in total? The methods of AB treating panel reports after appellate review. How many methods are there? 3, right? Good. What are they? Number one, agree with the findings and conclusions of the panel. Then the AB will uphold the panel reports, right? Good. Then if the AB objects the findings and conclusions of the panel reports, it will, the word is reject, disagree with the findings and conclusions. It would be reverse. Good, reverse. And what's the third method? There's another point. It's like this. The difference between uphold and modify is not that clear-cut. You still remember this point? We can say, after modify, then uphold. After modify, then uphold. And that's why the difference between uphold and modify is not that clear-cut. Then, under what circumstances this method will appear? The appellate body agrees with the conclusion of the panel report, but modify the reasoning of the panel, right? Modify the reasoning part of the panel report. So these are the three methods of appellate body treating panel reports after appellate review. 3. Okay, this is question number 1. Okay. Next question. Does the WTO dispute settlement system follow the principle of stare decisis? Yes or no? Take a guess. Yes or no?
No.
No. Okay, good. Then, another important point is, what is the legal status of the legal interpretation of the panels and AB? Legal status of the legal interpretation of the panels and AB. Are they part of WTO law? Yes or no? Are they part of the WTO law? And what is the name of this kind of legal interpretation? It's called acquis, or another word is called, yeah, that's the explanation of acquis. Another synonym, the synonym of acquis, we call it jurisprudence. The legal interpretation of the panels and AB is called the acquis or jurisprudence of the WTO dispute settlement system. Yes, exactly. It is part and parcel of the WTO law. It is part of the WTO law. You have to memorize that. Okay, good. That's the two basic questions I'd like to ask for what we've learned last week. Okay. Today, we are going to move on to next section. Section 5, the process of WTO dispute settlement. The process, the whole process. You can first guess how many types of proceedings are there throughout the whole process of the WTO dispute settlement. You can see here, 1, consultations, 2, panel proceedings, 3, appellate body proceedings, 4, implementation and enforcement. So there are 4 parts, 4 processes of WTO dispute settlement. We will deal with these 4 processes in turn. But prior to doing that, we need to first look at the general observations on the WTO dispute settlement process. General observations. Okay. Now, as usual, I will pose important questions to highlight the important points. Okay? These are the features or characteristics of the WTO dispute settlement. 6 features. I will not review them in detail and leave them to you for your learning after class. Okay. First, about the time frame. Subsection A, time frame, means the period of time that the proceedings will last. First, look at this paragraph. Okay, the period in which a panel must conduct its examination from the date that the composition and the terms of reference of the panel have been agreed upon until the date the final report is issued to the parties shall, as a general rule, not exceed 6 months, which means from the very beginning to the end, the time frame shall not exceed 6 months. That's for panel proceedings. You need to remember this number, this numeral. Okay. Go on. And in exceptional circumstances, the longest period can be exceptional circumstances. The longest time frame would be 9 months. Good. This is for panel proceedings. Then let's look at the appellate body proceedings. Appellate body proceedings. What is the time frame? What's the time frame? Also, two numbers. They are, yes, good. The basic time frame is 60 days. And in exceptional cases, the longest time frame should be within how many days? 90 days. Good. These four numerals are important, which need you to memorize. Okay. What's the difference between 60 days and 2 months? There is a difference between 60 days and 2 months. Why don't we just use 2 months here? Instead, we use 60 days. You think that's a cold joke? No, it's important. The difference lies the unit, right? Unit. The units are used to remind you the basic circles of doing something. For example, there are ships or vessels transporting goods from one port to another, right? But the shipment date, the unit for shipment dates are what? For example, we have one route. We have one ship every 1 week. You can never use 7 days because the unit for ships are calculated on the basis of weeks. We'd have 1 ship every 1 week. Okay, that's different. Okay, that's everything for this page. Now let's move on to next page. Actually, there is something I need to suggest. Is these 60 days and 90 days are criticized to be excessively short. It puts huge pressure on the appellate body and the disputants. Okay, let's move on. Here. Why? My question is, why would the DSU set time limits within such short time? Why? The time frame must be short legally because the WTO dispute settlement system does not provide for compensation for the harm caused by the measurement issue during the time the dispute settlement process is running. And that's why the appellate body and the panels need to speed up the process. Got it? Okay, good. Let's move on to next part. Next part is about the written submissions. The written submissions to the panel or the appellate body shall be treated as confidential. They will be de-restricted when the panel reports or AB reports have been circulated to the members. Why would they be de-restricted? De-restricted. Restrict. Restrict. De-restrict is the opposite of restrict. Means make it public, right? Why? Why will they be de-restricted when the panel reports or AB reports have been circulated to the members? Because the reports, when the reports are circulated to the members, then the reports will be made public. Yes or no? Yes. So at that time, the reports will be public, will be de-restricted. Okay, good. Another question. You can guess. When the panel proceedings and the AB proceedings are underway, do you think they are public or confidential? The panel proceedings, the AB proceedings, are they conducted in private or publicly? Take a guess. Just a guess. In private or in public?
In public.
In public? That's a good thing. And that's what we are expecting. But in fact, they are conducted in private, secretly. Okay? They are conducted confidentially. Okay. That's the principle. Okay. And there is a special party. We call it third parties. You still remember third parties? Besides the disputants, we've got third parties. Who are they? Who are third parties? Who are third parties? Okay, here. The meetings of the panel with the parties and the appellate body hearings are confidential. Just now I mentioned. Third parties are usually invited to attend. Third parties are usually invited to attend only one session of the first substantive panel meeting. The first thing I would like to tell you is there are 2 substantive meetings in total in the panel proceedings, while the third parties can only attend only one session of the first substantive panel meeting. So, what do you think of this kind of rights? Are they limited or are they broad? Limited, right? Good. Because only one session. What does session mean? For example, in every March in China, there will be 两会. What do we call them? 2 sessions. Good. That's one session. But this session is a little bit different with that session. This session just means one time. Maybe in the first substantive panel meeting, there are 2 or 3 sessions in total. But third parties are only allowed to attend only one session. So the rights of the third parties are rather limited. Okay. Good. Move on. This is something important. Why? Because later there's something we need to compare with this, with the rights of third parties. Okay? Good. Now let's move on to the subsection C, burden of proof. Burden of proof is something you learned in procedural law, especially civil procedural law, right? In civil procedural law, that course taught by who? Yes. Okay. Then, Who can tell me what is the basic principle for burden of proof? In Chinese, it's called 举证责任. Yes, good. What's the basic principle of burden of proof in English?
In English, I don't know.
In Chinese.
谁主张谁举证.
Good, exactly. Actually, the translation is just lying here. You can see the words in red. Okay. The party who asserts a fact. In Chinese, it's called 谁举证, assert a fact. 谁主张, sorry, who asserts a fact. Whether the complainant or the respondent is responsible for providing proof thereof. Not difficult, right? Good. Okay, move on to next page. Next slide. Have you noticed the important point? The basic principle of burden of proof is related to facts or legal interpretation. Let's go back and review the principle. The party who asserts a fact, it has nothing to do with legal interpretation, right? It's in the proceedings concerning facts. Then look at this sentence. The rules on burden of proof are relevant with respect to issues of fact, but not with respect to issues of legal interpretation. Okay. Then let's move the question a step further. Will the burden of proof be subject to the appellate review? Again, I will repeat the question again. Will the burden of proof be subject to appellate review? Where's your company? Your company means your peer. Why are you alone today?
Because I'm late.
Then, a question. Will the burden of proof be subject to appellate review? Panel proceedings, appellate, sorry, AB proceedings. Take a guess. First point you need to know is burden of proof is about facts, yes or no?
Yes.
Then, will the facts be subject to appellate review? I mean the second instance of legal proceedings. Yes or no?
No.
No, good. Is that difficult? Okay, good. Next point. it relates to a technical word. It's called jura. Look, jura novit curia. It's a Latin word. Jura novit curia. You need to know that. I will explain it to you, okay? Jura novit curia is a Latin legal maxim expressing the principle that the court knows the law. The court knows the law. That is, the parties to a legal dispute do not need to plead or prove the law that applies to their case. The maxim is applied principally in civil law systems and is part of the investigative aspect of that legal tradition, as distinguished from the more pronouncedly adversarial approach of common law legal systems. The maxim is first found in the writings of medieval glossators about ancient Roman law. There's a difference between civil law system and the common law system. What is that? I'll give you a hint. In civil law system, such as China's legal system. Actually, China's legal system is not a civil law system, but more similar to civil law system. Let's just take that as an example, okay? In a court of civil law system, who will dominate the whole process? Good. Very good. In civil law legal systems, the judge will dominate the whole process of the legal dispute settlement. Well, in common law system, who dominate the proceedings? Who? 金爷, out loud. Then in Chinese, I allow you. Huh? Jury. Okay. Just now, Jingye said jury. That's criminal proceedings, right? Good. In criminal proceedings, the jury decides whether the suspect is criminal or not, right? Juries. You can always say the parties dominate. The parties means the plaintiff and the defendant. The prosecutor will prosecute the suspect, the defendant. Or in civil law disputes, the plaintiff will sue the defendants. Parties dominate the proceedings. Okay, that's the difference. Then, if in civil law system, the judge dominated the whole process, then the applicable law, who will decide the applicable law? Of course, yes, good. Also up to the judge. It's also up to the judge. And that's why we say this principle, jura novit curia. That means the court knows the law, right? The court knows the law. Good. Another important issue is subsection D, the role of private legal counsel. In practice, who can represent the complainant and the respondents in WTO dispute settlement? Who can represent the parties? Here, the word in red. Only government officials could represent parties and third parties, which means only the trade officials in the Ministry of Commerce, for example, in China, can represent China in a legal dispute of the WTO. Only trade officials. There are no counsels or lawyers involved. But in some poor developing countries, even the trade officials know nothing about the WTO law. They will have to employ lawyers. And in this context, we call them counsel. Legal advisors or counsel. Are they expensive or cheap? Take a guess.
Expensive.
Good, very good. Change it to another word.
Huge. Huge.
How to spell it?
Huge.
Huge. Huge costs. Good. Also right. Then, another word. You still remember the word I mentioned? I'm not the god of drug. I'm not the drug god. Dying to survive. The generic medicine is prohibitively high. So, this word can also be used to express expensive. Very, very advanced word. When you are taking the exam of IELTS, you will leave a good impression. Prohibitive. Too high. The price is too high, so that I'm prohibited. I cannot afford it. Prohibitive. Good. Okay, let's move on. Okay, on this slide, let's focus on the amicus curiae briefs. Amicus curiae, what does amicus curiae mean? Amicus curiae, in English, it's called the friend of the court, right? The friend of the court, amicus curiae. Who can be amicus curiae? Who can be amicus curiae? Friend of the court. Who can be? 3 members. Okay? Shi Mengping, would you please tell us who can be members of amicus curiae? The answers are just lying in the words in red. 3 members. Written briefs submitted by. You don't know that word? Okay. Individuals. Next one. Companies, you cannot recognize that word? The last one. Okay, take a seat. Okay, please. Here, written brief submitted by individuals, us, companies, also private parties, right? Organizations. Are organizations private parties or public bodies? There are public organizations and there are also private organizations, but in this context, it should be private. Why? Because it's individuals, companies, organizations. Do you think the United Nations will come to this forum and submit written briefs? Of course not, right? So, it should be private organizations, non-governmental organizations. Listen, non-governmental organizations are private organizations or public organizations. Non-governmental, private or public? Huh? Your answer. Non-governmental organizations are private or public organizations.
Wrong.
You mean the... Stop using your Chinglish. Okay. You can say no. No. It's a choice question. Public or private?
Public.
Non-government organization is a public organization. Where is your common sense? Take a break of 5 minutes first. We'll come back later.